Thank you very much, Kevin. Ladies and gentlemen, colleagues and friends, good afternoon. Well, rather good morning from Paris, and a warm good afternoon to all of you. It's a great pleasure to join the launch of the 2021 ICC arbitration rules in this event for our Korean colleagues and friends. And it's a great opportunity to reconnect with many of you whom, for reasons, unfortunately, that have become routine, I have not had the pleasure to connect with over a long period of time. In the few minutes that have been very graciously allocated to me this afternoon, I'd like to share with you two main perspectives, if I may. The first one, and I will do so, of course, in English, given that my Korean is unfortunately a little bit rusty. The first concerns, of course, the revision process of the rules themselves, the goals that we set out to achieve through that process, the various circumstances that perhaps affected positively, I think, the revision process itself and the actual outcome of it. And then perhaps on a second stage, I would also like to share some perspectives with regard to where the introduction of the new ICC rules finds ICC dispute resolution services at the beginning of 2021, and what our expectations for this new year will be. To start, therefore, with regard to the revision process itself, I think the characteristic of change is one that has defined the ICC court, its secretariat, and its overall activities since its inception in the early 1920s, nearly 100 years ago. And that need of change, I think, is reflective not just of the need to make sure that we provide service excellence, but also to ensure that our proceedings are structured in such a way that make efficiency and it provides sense to the users and the various stakeholders of arbitration worldwide. Ultimately, of course, good process and good administrative solutions provide additional safeguards with regards to ICC awards being enforceable at law, which is, of course, the ultimate goal in which arbitration stakeholders strive for. And therefore, any revision process of the ICC rules, including, of course, the one that has led to the introduction of the 2021 rules, is basically twofold. On the one hand, it aims to crystallize practices that have formed in the application of previous iterations of the ICC rules. And again, given that case administration and arbitration itself are living organisms, solutions are always put to the test, they are applied, and very often there is a need to adapt or conform the way that they apply with regard to the circumstances of specific cases and new circumstances that arise. And that adaptability is what leads, I think, to the formation of practice, the emergence of new solutions, and ultimately the need to incorporate these solutions once they become standard into a new set of rules. At the same time, the revision process would fail if it merely encapsulated crystallized practice, because ultimately that may not lead in and of itself to a full-fledged amendment. The second component part, which I think basically guarantees the success of an amendment process such as this one, is the introduction of additional solutions in case management and in the way tribunals may conduct proceedings that ensure the progressive development of international commercial arbitration, and therefore confirm again that overarching goal or characteristic of dispute resolution, which is, again, change. So as the ICC court began the revision process, very timidly at first, of the 2021 rules, it set out to achieve this double goal or double mission. In terms of process or history of this amendment, it started probably around the very beginning of 2019 in a series of internal discussions between the leadership of the court. You already heard Alexi Moore speaking with regard to the process itself. the leadership of the Secretariat and my core team, and a dialogue we have had with the Bureau of the ICC Court, namely the President and the 17 Vice Presidents who very regularly chair the ICC Court sessions, literally day in and day out. The ICC rules provide for a very transparent and I think governed process whereby the rules are amended. And it is, I would say, a very participatory, if not also very democratic process that is followed. Any initiative that comes from the court, and therefore the Secretariat and the court, with regard to the revision of the ICC rules, needs to be laid before the ICC Commission on Arbitration and ADR, which is, in a way, the ICC institutional or legislative branch, a think tank of sorts that provides input on a number of activities that, again, progressively develop our common understanding of dispute resolution and dispute resolution process. The ICC Commission is a body that has about 600 members, most of them, if not all of them, nominated to the Commission by ICC national committees, and therefore it is representative of the full spectrum of the ICC network. The discussions between, or the dialogue between the Commission, its members, and the court lasted for a number of months. There were two full debates that took place in the Commission's meetings that were organized in Seoul at the time of the IBA annual conference in 2019, and then again last summer virtually through a meeting conducted in July via Paris and a number of other cities. In between, there were many exchanges between Commission members, national committees, the Secretariat, and the court that provided additional refinement to the solutions that were ultimately adopted and agreed upon through an approval process that led to the adoption of the ICC 2021 rules by the ICC Executive Board. The new rules are a month old, literally to the day. They came into force on the 1st of January this year, and they have been complemented with an update to another, I consider, useful tool that the ICC Court has elaborated over the years, and that is the ICC note to parties and arbitral tribunals on the conduct of arbitration. I have posted links in the message chat window to both documents, the ICC 2021 rules and the note, which are already available online in English, as the translations of those documents into Korean and a number of other languages are underway. Very broadly speaking, and without wanting to take anything away from the very useful contributions that will be made by my distinguished panelists in the discussions that will follow, there are four broad chapters, in a way, that are encompassed and covered in this revision process. The first one takes stock of the need to use an amplified approach towards technology. And it may seem quite mundane after 12 months of into the COVID crisis to speak about the use of technology in arbitration, yet to a certain extent, the ICC rules required perhaps to again set out with more clarity matters that had already been there and applied for some time, such as the use of soft copy over paper, or the possibility of arbitral tribunals to consider the full logistical consideration, the full logistical options that they have in organizing arbitration hearings, and therefore deciding on whether to hold hearings in a fully in-person or physical manner, in a virtual manner, or ultimately by using a combination of the two, and therefore creating the circumstances for hybrid hearings. The ICC rules have been traditionally hailed as a tool that allows for the organization of very simple arbitrations, but also complex arbitrations. That has been one of the main innovations of the last major rules amendment that took place nearly a decade ago. In furtherance of that specific goal, the ICC 2021 rules further complement the solutions that are available in the advent of complex arbitration and have provided additional clarity and solutions in the context of the joinder of parties once the arbitral tribunal has been constituted, in the consolidation of pending cases under certain circumstances where so doing would increase the efficiency of the dispute resolution process and lead to the saving of time and cost, and ultimately by introducing a novel provision that allows for the ICC court to exercise discretion in appointing the full members of the arbitral tribunal in situations where an ICC arbitration agreement may be unconscionable. And in this regard, I think the ICC rules, the new ICC rules, have already been vindicated in terms of the solutions that they have adopted. If one looks into the very recent judgment by the Paris Court of Appeal in its judgment of PT Ventures that was released last week and already reported in the legal press. Efficiency of arbitration, to which I've already spoken about, is again an area which requires additional complementation, and that is something that has been done in the context of the 21 rules by expanding the use of expedited arbitration on the one hand, and ultimately in a certain easing of conditions for the applicability of the emergency arbitrator provisions. Conduct of arbitration has also required or has also benefited from additional solutions. An arbitral tribunal may, under the ICC rules, may now consider the circumstances where it has to safeguard its impartiality vis-a-vis the introduction of additional counsel. Parties are required to disclose the existence and identity of third-party funders, again to safeguard the impartiality of arbitrators. And ultimately, arbitral tribunals have the power to encourage parties to consider settlement, mediation, and other forms of ADR to the extent that that would lead again to the proper settlement of their dispute. Finally, and as a nod to the need to, again, instill governance and transparency to the operations of the court, the annexes, the first two annexes to the 2021 rules, provide for further structure, for a more structured and organizational reset of the composition and operation of the ICC court. And finally, they also provide now clearly in the ICC rules the conditions under which the ICC court may communicate under certain circumstances to the parties and the arbitral tribunals in a case, the reasons supporting its decisions on a number of matters, such as challenges, consolidation requests, prima facie jurisdictional assessments, and the situations of appointment of the full arbitral tribunal. As I mentioned earlier, this amendment process is not an introduction of solutions that should be read in isolation to other aspects of our institutional activity. The process of transforming our services and ensuring that we provide a tailor-made and contemporary support to the dispute resolution process is one that has begun over some time now. The circumstances under which the ICC court and its users had to adapt their practices over the past 12 months to ensure business continuity at a time of an unprecedented crisis that threatened the welfare of humanity and, of course, the activities of international trade and dispute resolution required that. And therefore, as I said, many have already mentioned that the institutions had to take the initiative to provide guidance to parties and arbitrators on how to mitigate the potential adverse effects of the COVID pandemic in dispute resolution. I'm very satisfied that the ICC court was amongst the first, if not the first institution to provide concrete guidance to the users of arbitration in this field already as of April last year. And many of those practices have found themselves integrated, not just in the ICC rules, as I've just mentioned, but also in the practice note that has also been amended last year. At the same time, ICC continues its other efforts in order to proliferate the good uses of international arbitration and dispute resolution. The drive for transparency continues, as I mentioned, by our implementation of the policy that was announced by the ICC Court already 2 years ago in terms of publicity of arbitral awards in a setting and under conditions that the parties would allow for such a publication to take place. This is a project that will officially launch in April this year. It is well underway and being implemented. At the same time, ICC is expanding its footprint by opening an additional case management office in the Gulf at Abu Dhabi Global Market, which the launch of which will again coincide with the beginning of April and the launch of the publication of awards. And at the same time, the ICC Court is going to replenish, as it does every 3 and every 6 years, depending on the circumstances, its full membership, but also its leadership. And by the end of June and the beginning of July, a fresh court with a combination of new court members and existing court members, a presidium of existing vice presidents and new vice presidents, and ultimately a new president will take the helms and lead ICC dispute resolution to new heights. In concluding, I would like to thank you all again for very graciously and kindly participating in this launch event. And I would like to give extend my particular thanks to Sun Yung for all the laborious efforts that she has put forward to make this event and the Young Arbitrators event that follows in a few days possible. And lastly, to my good friend, Kevin Kim, my sincere thanks for all the work that he has assisted the ICC Court in moving forward in his many years as a member and vice president of the ICC Court. Thank you all very, very much.